This is the New York Times Company versus Sullivan, 1964, James Powell, Full Sail University. Today we'll be looking at a case of New York Times versus Sullivan, 1964. The case revolves around the advertisement entitled, "Heed Their Rising Voices," accusing Montgomery police of an unprecedented wave of terror on the campus of Alabama State College. The ad's purpose was to solicit funds for the defense of Dr. Martin Luther King and, by proxy, the civil rights movement. In this pivotal court case, the plaintiff, L.B. Sullivan, Commissioner of Public Affairs for the city of Montgomery, Alabama, claims the New York Times did willfully print an advertisement about civil rights violations that defamed the plaintiff. Although not directly named in the publication, he claims that because of his position's oversight and authority, he was defamed. In defense, the New York Times asserted that they had protection under the First Amendment. So let's look at Sullivan's burden of proof. The publication. Did more than one person see that publication? The obvious answer is yes. It was in the New York Times. Identification. Does it identify the plaintiff by name or inference? Although it does not specifically name him, he argues that due to his position, he is inferred. Defamation. Does it hold the plaintiff to public hatred, ridicule, or scorn? He argues that he had been libeled by statements critical of the police. Fault. Was the publication at fault for publishing the defamatory statements? According to Sullivan, the New York Times was at fault for publishing the information. Did the information come from reliable sources? Though the clergy is typically considered to be reliable in the United States. Is information probable? In other words, was the information so unlikely that it cried out for further explanation? The information was probable. Were there some known facts omitted that would have established the falsity of the statement? According to the New York Times, there were some facts that were misrepresented. Were warnings that the information was false ignored? Yes. A retraction letter was sent to the Times, but it was ignored. Were inconsistencies with the information disregarded? Again, the Times admitted that there were minor inconsistencies. Falsity. Is there proof of malice? There was no proof of intentional malice, at least on the Supreme Court side. Injury. How was the plaintiff injured? He claimed his reputation was injured and therefore was entitled to punitive damages. The Alabama courts found in favor of the plaintiff, and a jury awarded him $500,000, and this was affirmed by the Alabama Supreme Court. The jury found that the New York Times was guilty of ad libitum per se and of concerning, and accountable without proof of malice. The New York Times appealed the decision to the Supreme Court of the United States. The Supreme Court, in a 9-0 decision, cited in favor of the defendant, the New York Times, overturning the verdict of the Alabama Supreme Court. In doing so, the following precedences were set. The protections of the First, as applied to the states through the 14th Amendment, protected political messages that are published in the form of paid advertisements. They also set the precedence that it is a violation of the First, as it applies to the states through the 14th Amendment, to assess damages for libel against public officials for criticism of official conduct without showing of absolute malice, knowledge that the material is false, or reckless disregard for the truth. Chief Justice Brennan went on to say, "I strongly believe that the Constitution accords citizens and press an unconditional freedom to criticize official conduct. It necessarily follows that in a case such as this, where all agree that the allegedly defamatory statements related to official conduct, the judgment for libel cannot constitutionally be sustained. In the court's opinion, Chief Justice Brennan gave the following reasons for judgment. 1. The First Amendment applies to the advertisement in question because it is an editorial rather than commercial in nature. Alabama's lias per se rule violates the First and the 14th Amendment when applied to publications about public officials. First Amendment designed to ensure uninhibited, robust, and wide-open debate on public issues. State law is not saved by providing for defense of truth. A defense for erroneous statements honestly made is no less essential here than in the requirements of the proof of guilty knowledge. Self-censorship occurs where there is doubt about truth of an item or being able to prove the truth in court. They go on to say, public officials cannot recover damage for defamatory falsehood relating to their official conduct unless a statement was made with actual malice. Actual malice is defined as knowledge that it was false or with reckless disregard of whether it was false or not. In reviewing the evidence, the court finds that the proof presented at the trial did not establish actual malice because there is no evidence that the paper was aware of any erroneous statements or were in any way reckless. The court follows Sweeney v. Patterson and distinguishes Valentine v. Christensen. The court rejects application of actual malice standards because it is too vague, and the First Amendment provides absolute protection for criticism of public officials. As public relations professionals, we have a responsibility to be ethical, not only to our clients, but also to the public. Whenever we put together a piece for a client, we must avoid liable actions that can have negative effects on our clients, public, or ourselves. To make sure we do not commit liable acts, we must back up all opinions with facts. Make sure all quotes are accurately expressed with the facts. We do not identify, suggestive or otherwise, anyone without facts. We're cautious of news items that could defame. We use accurate photos. We keep notes and tapes of all interviews. And we edit all material for offensive material. The key to success as a public relations professionals relies on our ability to maintain the highest of ethical standards while still proving the greatest value to our clients. This can only be accomplished through vigorous and oft-times brutal honesty in all endeavors, be it press releases, blogs, social engagements, or traditional media. I'm James Powell. Thank you. I'd like to give a special thanks to Professor Chris Cobaugh of the University of Missouri, Kansas City. He's a professor of constitutional law and also the Kansas Secretary of State. I would also like to give special thanks to Derek Schmidt, the Kansas Attorney General. I utilized both of these resources while researching this project.